Well, good morning to everyone. Thank you for attending to this webinar on the European AI Act, and where we are going to be answering some questions from our clients related to all the new regulations on AI. Before starting the webinar, I would like to go into some specific recommendations. If we can, maybe, yeah, thank you. On technical specifications from webinars that you more or less you might know, but just to go through them. Microphones are muted. Please submit your questions through the Q&A function. You can do it anonymously if you want it. And we will have live interpreting with humans into Spanish and into German. You have the section, you have the choice at the bottom. I'm not really sure which button it is, but you have a button where you can choose the language where you want to use to listen to the webinar. As we advance, and as many other webinars, we will be recording the webinar and sending the recording to you. And of course, we will have a Q&A session at the end. If it's longer or shorter, it will depend a little bit on how the presentation goes. But nevertheless, please ask all the questions through the Q&A submissions function or through the email, and we will be more than happy to answer all the questions after the webinar. And allow me just to go into the presentation of Paula Ortiz. Paula Ortiz are the person that is going to be presenting and sharing with us all the insights. I know her since a long time ago. Actually, I have to thank her for having time to collaborate with us and help us to answer the questions from most of our clients. She's a very well-known digital law expert, co-founder and CEO of the Legal School, and she has over 20 years of expertise on data protection in several positions. And well, thank you, Paula, for coming. And for those of you who don't know me, I'm the director of AI and in AI solutions and innovation. And I'm going to be behaving here just as a moderator and give the stage to Paula, which I'm sure she's going to be sharing loads of insights and very interesting matters on the AI law. Paula?
Thanks, Maria. It's a pleasure to be here with you and with your clients and with people interested in artificial intelligence regulation. It's something that it's quite hot issue right now, and I think that all of us should have somehow like a picture of do's and don'ts, what we have to do. No, so we are going to start. We are going to have about 15-20 minutes of presentation about the main lines. I guess there are no lawyers here, so I think that we can, it's not necessary to go very into a very deep detail on these matters, just to have, as I was saying, like a broad picture of what is happening, what are the main obligations, what are the main prohibitions, and what things we should take into account. So we have a law. This regulation is a quite complex law. It has more than 80 articles, it has annexes, it has recitals. So you need a lot of time to read it, you need a lot of time to understand it, and the most important thing, we are not prepared still. We are not still prepared to see the practical impact of that, because we are on the move. It's a quite new law. It was published in the journal, in the European Journal, in August, when all of us were on holidays. And we have, as we will see during the presentation, there are only two obligations right now since February, and the rest of the obligations will come into force in August. So we are going to have this picture. It's important to take into account one thing. This law, as the General Data Protection Regulation, that is something that I will mention, and the Digital Services Act, this law is not an isolated law. It is a part of a wider framework of European laws that are applicable not only to European companies, but to companies that are making businesses and processing data and using AI in the European territory. Okay, so it doesn't matter if you are in Japan, in Palo Alto, in Israel. If you are using AI in the European Union, you will have to comply with this law. We have these debates on United States non-regulatory approach, China and Europe. But I'm going to explain, of course, how's the thing in Europe. So, as I was mentioning in advance, this law is applicable when you are placed in the European market and you are having a service into this market. When you are deploying, when you are using this an AI within the European territory, and it's important when the output is generated or is used in the EU. So if you are DeepSeek in China, or you are OpenAI, or you are every single LLM or a smaller company deploying an AI, but you produce outputs, or you allow that people is using this information in Europe, you will be also part of these obligations. Okay. It's important to have to bear in mind that most of European laws has this approach of people affected is located in Europe. It also happens, for example, with General Data Protection Regulation. As I was saying, doesn't matter if you are anywhere around the world. If you are processing data in Europe, you will have to comply, and you will have to name a representative in the European Union. Most of them are in Ireland because of a foreign shopping situation, and we are not going to enter now into the details of how this enforcement works. But you have to take into account that this law is not only for Europe, but for companies that are operating in Europe. It's not my idea to develop, I don't know if it has like 60 definitions, the law, but I think I'm going to have these two ones that are important for this presentation. First, provider, that is the organization that is developing an AI system, or for which this AI system was developed. And this provider is going to place it on the market. So it doesn't matter if you develop or you are using a developed AI, if you are placing that on the European Union. And most of you probably will be a deployer. What is a deployer? An organization that is using an AI system under its own authority, except when it's used for a personal, non-professional activity. All of us here are on a professional activity. If we are at home using ChatGPT, we are not a deployer. But if we are using AI as a service or something like that, we are a deployer. Okay, so we will see later on that we have an obligation called AI literacy, but I will speak about that later on. Okay, so normally it is said that that this law is quite hard, and it prohibits a lot of situations, but I have to clarify one thing. This law is not prohibiting technologies. It is about uses. I mean, it depends on what you are going to use the technology, it will be forbidden, it will be considered like high risk, it will be considered like medium risk, but it is not a matter of forbidden this kind of technology. Because, for example, you can use generative AI for one purpose, and it could be violating fundamental rights. So it will be forbidden, but you can use the same tool for other purposes that will have like some kind of a high risk approach, and then some obligations. So this is just like a very graphical picture of how is the law. So we have like prohibited practices that are already into force since February this year, that as I was saying, violates the rights and values of the European Union. Then we have these high risk situations in which it has impact on basic rights. Medium risk, for example, it could be the use of generative AI, that we need to bear in mind that we have to be transparent with that. And for example, spam filters or recommendation systems that has not problem, they are not problematic. So this is another way to see it, no? And later on, I will explain more in detail what are the prohibited uses. But for example, in high risk, we need to bear in mind that if we are using AI for recruiting systems or law system or automated access control, we will have to comply with a lot of obligations that I will mention later on. For example, make like an impact assessment, included that on a database within the European Union, in order to allow the Commission to know what is happening with the AI developing software, so to say. Then we have this limited risk approach, that it's about, for example, customer support chatbots and personalized recommendations. As you will imagine, here the main obligation is transparency. It is something that we not always it is given all the importance that it has, the transparency, in order to empower the citizens and the users to exercise their rights and to know all the information. And then we have this minimal risk that doesn't have many obligations, because it is a matter of that there are not any risky situations within that. As I was saying, since February this year, there are situations that are forbidden. I mean, we cannot develop, we cannot use or deploy AI for these purposes. For example, the interference in emotions in workplace or in institutions. There are already technologies that allows employers or education institutions to measure how is these workers or students by analyzing their faces, their voices, their tones. It is absolutely forbidden. Why? Because of the hierarchy situations, and in the end, it's a matter of having an invasion of their privacy, that it's a fundamental right. Then we have also, it is forbidden the remote real-time biometric identification in public places or policing. But here I have to say that it has an exception. The army and for defense purposes, it could be used. There is something also that is forbidden. For example, the exploitation of vulnerabilities. We have to bear in mind people with disabilities or unfavorable economic conditions or children. As we all know, AI can customize the messages and adapt it to our needs. And there are some kind of collectives like children and these people that can be less prepared for this kind of situation because of this vital moment, so to say. So it is forbidden to use AI for this kind of collectives. This is quite related to subliminal manipulation, subliminal influence, that it's a matter of using what the algorithm knows about you to forward messages and to use it to change your behavior, for example. And this is something that could sound like a dystopian, but it's already happening in China. Social scoring and social behavioral personal characteristics in Europe is forbidden. I mean, we cannot use information to make some kind of good of bad citizens. So why, as I was mentioning, why is this forbidden? Because it's directly violating fundamental rights at the European Union. Okay, so since February, no AI can be used for that. The other obligation is, as I was saying, the AI literacy. The AI literacy is also in place, and it's the obligation to train teams that are using AI. This is something that it is not very well known, and normally people think that you can comply by making an online general course, but it should be an ad hoc program dedicated to see how are you using the information and the AI system to educate your workers, not how they can use the AI. Can I upload contracts? Can I use generative AI to create images? Will I have the rights over this information? Of these kind of questions that are normal and a lot of people is having in the companies had to be solved with this AI literacy. And it is something that companies are already putting in place, this kind of educational paths for their workers. The Commission has made some kind of clarifications with regards to these situations. And these are like that. For example, the workforce does not have to be formally certified, and records should be kept for the training sessions. So as you can see, these are some kind of guarantees that demonstrate to the Commission that you are complying with this situation. When we talk about a high-risk system, we are not going to go into very much detail with regards to that, but if we are developing these high-risk systems, we need to have this technical documentation. Here I want to clarify that this technical documentation is how this AI works. I mean, it doesn't mean that if you are working with technical documentation, you are using a high-risk system. It means that if you are using AI for high-risk purposes, you need to
write the technical documentation. To write the technical documentation.
To write, yeah, and yes, to have it at the Commission disposal. It's quite important to bear in mind that human oversight, human in the loop. It means that every single time that you are using AI to create anything, you have to be transparent with the fact that you have used this AI, and no decisions can be made without this human oversight. Okay, this is one of the most important issues of the regulation, to avoid unfair consequences. You also have to have this risk management. It means that it will depend on the concrete purpose you are going to use that, to see what other obligations you will have. There is also an obligation to try to detect biases and try to correct it. This is something quite difficult because normally these biases come from many sources. It comes from the people who is developing the AI. It comes from the data you have feed the AI. It comes from the way you have interpret these results. So you will see that by the end of this presentation, what I'm going to recommend you is to have a responsible IA program within the company that also takes into account a diverse. It's important to have a diverse group of people monitoring how is the AI developed in your company. And normally it comes with people from different areas, not only the managing department, of course, women and men, but also young people, old people. I mean, to try to have a wider view of what happens. No. Yeah, you also have to have this data governance and this transparency obligation. This transparency obligation, if you want, Maria, then we can talk a little bit later if someone is asking about how it works or whatever. But it's important, as I was saying, that you are transparent with the fact that you are using AI. This document, this product, this translation, whatever, has been made with the help of an AI system, okay? And it is also a matter of accountability, and it will avoid problems to everyone. Of course, as I was mentioning before, if you are using a chatbot, if you are using some kind of agent that has a relation with people, there are times that it is quite obvious that you are talking to a machine, but as we all know, the technology is developing quite quickly and it's evolving. There will be a time in which we are not aware of what are we talking to. So it's important.
And not everyone is that aware of how technology is evolving. So maybe not everyone has the capability of detecting when there is a machine or not. So labeling, as yours, what I understand is that labeling is very important.
Yeah.
Okay,
It's quite important in the end. I think I always say that transparency is the word of this year, because transparency allows people to understand why are we using their data, why are we using these tools, and allows us to have the possibility to react. Otherwise,
to choose. Yes, good. Thank
it's
you.
impossible. Yes. And yes, as I was saying, the other day I was reading that it is called like the Blade Runner law. It means that you have to be transparent with the fact that behind your conversation there is a robot. So in the end, it's the obligation to inform the user that they are interacting with an AI system, and the obligation to implement techniques and methods to detect that the output was generated or handled by an AI system. So we are now on the move. It's a quite new technology and a quite new law. We are developing on the way, but we have to bear in mind this kind of situations. It's important to explain the difference between explainability. And I will try and I will take advance to say that explainability in Spanish has a very hard translation, because it doesn't exist in Spanish. So explainability and transparency. Explainability is the obligation for us to make users understand and trust the results created. So we have to explain what are the processes that the AI had to get this output. Okay, and also is the transparency that it means that the system should be able to be explained in a non-technical way to someone who is not an expert in the subject. So you have to explain the processes, and you have to explain how it works in a very easy way. why is it necessary to avoid the echo chambers, the black boxes? And as I was saying, it is not a matter of only the AI Act. It is also an exigency of the General Data Protection Regulation and the Digital Services Act. Here, it's a very practical tool that I want to show you. It's what is called model cards. Model cards are developed by Hugging Face. It is a way to make like an own audit. Here, it's a very visual presentation, but my recommendation is you to go deeper into these model cards functioning, and it allows you to think and to reflect what are the model details, what information you are using, what is the intended use of the technology you are going to use, what are the performance metric. Also to explain what kind of data you are using to train this tool, and what are the potential biases you may have. Potential, I will say potential, because you may have another biases that you haven't localized, and then also have these ethical considerations and recommendations. So as I was saying, this is like a presentation card. It could be like the label we find in the clothes. You can wash these clothes in 30 degrees or not, or you can iron that. It's a matter of knowing what is behind, and it is something that I really recommend to know what is happening in the company. And here, this is something that we have to speak about. It's the penalties. They are quite high. For example, the General Data Protection Regulation, it could be until the fourth percent of global turnover, or 20 million euros. The one who is higher. This is the GDPR that we thought that it was quite high. And with the AI Act, it will be the seventh of the global turnover. So it is something that it has been quite criticized by, for example, the US government with regards to US companies that operating here. But this is something that I have to mention. I mentioned it in the beginning, but I mention it again. In Europe, the regulation is focused on human, it's human-centric. It protects people, and not everything is allowed. Today, with this 20-30 minutes we are dedicating to this presentation, of course, we don't have time to go deeper into the different obligations, but I'm also an entrepreneur, and for me, it's hard to run a business with all these obligations in Europe, but on the other hand, people is protected against secondary uses or uses that are not good for society. Here, and for the last minutes, I want to speak about responsible IA. Responsible IA, it is something that as you can see, more than 80% of organizations already believe that should be a strategic priority. And I think you guys are on the same side, because otherwise you wouldn't be here in this seminar. So 52 of companies are already implementing specific programs to tackle these issues, and almost 50 is expected between 2021 and 2030, rising from 54 to $819 million in the market associated with AI governance. So as you can see, it is something that it's a priority. So what is responsible AI about? It's about mitigate biases in data and algorithms. It's about implement transparency AI. It's about to protect privacy and data security, impact on customers, complies with current regulations, and also to bear in mind that it has an impact on business. Nowadays, it's difficult, if not impossible, to to launch a business or to think about a strategy or whatever without bearing in mind the legal consequences, because you are going to be required by the rest of your providers, vendors, or clients. So in the end, it's something that you have to bear in mind. So thank you, gracias, vielen Dank. It's been a pleasure to have a view on this regulation. And I don't know, Maria, if you have any questions.
To be honest, we have
from the
some
panel.
questions here in the, well, you continue. Yeah, thank you. We have a few questions, and maybe I can just read a few of them, and we can answer the ones that we have time for. The first one is, are there any rules about how we must mention AI was used, a way of labeling, a specific way of labeling? This is AI generated, AI was used.
There are not concrete, it is not mandatory to have a concrete sentence or label, but you can use, with the help of AI, produced by AI, AI, you can be creative with that, and it depends if you are mentioning that in a contract or you are mentioning on internet, but there is not a concrete obligation. The law, Article 50, states just that you have to be transparent with the output and with the fact you are using AI.
Okay, that's quite interesting. Actually, I have to thank you also, because I took some notes myself, and there are lots of things very interesting that you are mentioning. We are learning a lot, so thank you. We have another question. I'm going to be reading. Thanks for the presentation, Paula. Who is responsible for checking that companies follow the European AI Act and for giving penalties? Is this the same as in all European countries, or does it change depending on the country? The application of the European Act is applicable everywhere the same way?
Good question. European style, we have like 27 AI offices. In Spain is in A Coruña. And the funny and being sarcastic thing is that this authority was already there without the law. So we had civil servants working on something that still didn't exist. But yeah, we have national artificial intelligence offices, and then the commission coordinates the works of all of them. And if there are many things, for example, the commission is directly enforcing the forbidden uses that regards to infringement of fundamental rights. And then in Spain, for example, and I don't want to speak just for Spain, but we have the Spanish Data Protection Authority, that it's the authority that will have to control data and algorithms. But
Right.
yes, there are offices that related directly with the AI, and they meet in Brussels, and they put in they share experiences and take coordinated decisions.
Okay, that's quite interesting, actually. So there is a lot of control being expected in that matter, because there are a
Yes.
lot of offices and a lot of coordination. So I have another question here. People is getting is interacting a lot. Thank you so much. How much for employees be done? Is it enough as an internal policy? Add something in the contracts? Do we need to hire experts to do the training, professional trainings, or can we provide it internally by an internal policy? I'm adding to the question.
This is a very interesting question too. We have to keep records of this AI literacy path. And of course, it can be given internally, but it has to be given by teams that knows
But you use it, I
about
guess.
regulation and what are the different obligations and prohibitions. So if you have a legal team that is ready and it is already it has information on that, I think there are no problem with the fact of demonstrating that you have educated your teams with that. Yeah, but you have to be able to demonstrate that your teams has already see what are the possible effects of this kind of uses. So there is no concrete prohibition.
Okay, it's very interesting because we are actually doing some trainings internally, and we have an AI policy that is available for all our employees. So somehow we are covering, but actually, after contacting you and having some chats with you, we are actually enforcing a lot that part of the training also, so that everyone is aware. I mean, we have teams of expertise, so it's somehow something that we can do. But thank you. Like, we will be encouraging also to improve that part. Another one. Hi, this is Deb. We have used AI several times in the past. Do we also need to mark this older content as AI generated because of the transparency rules? Or is this rule only applying to the content created from August 25 onwards?
Yeah, I mean, it doesn't have a retroactive
Right?
obligations. So, but if you have used these AI systems, for example, to create a logo or a creativity or something like that, I could be transparent with the fact that I have used some brands or whatever, just because in the future could be someone that is using your creation to its own purposes, and you may not have rights on that because you have used AI system to develop it. And here would be another debate and another class of what happens with creativity and with authorship and originality of these creations. So with regards to that, I would recommend to be transparent. But if you are using outputs right now, I mean, it's a matter of being transparent of what you are doing right now.
Okay. And we have another question. For which type of content or documents is transparency required? Is it acceptable to just add a small sentence at the end? I think this is more or less answered, like how we can do it is up to us, but which type of documents or content is required to be, the transparency is required to level that we have
There
generated.
is not a concrete list of documents
Okay.
that has to be part of these obligations. We are talking about outputs. We are talking about the using of technology. So, for example, if you are using AI to help you, for example, giving legal services, you have to say, I am using AI for giving you legal services, and my tool is this one, and my data are here, and my sources are here. And you don't have to say in the contract, for example, this document has been created using AI. But if you have a contract with clients, you can say we are using AI systems, and our systems are this, and this, and we are able to explain what is the process we have used to produce this output.
So I guess that probably it is not something that we have to do in every single document that our clients are creating, but in the contract with their relation with their own clients, we have been translating, or we have been
Yes.
creating this document with AI, or we will be using AI to help the.
We will be using this concrete tool for these concrete purposes. Yeah, and also be ready to answer more concrete questions of what is the process of to get to this result. Yeah, it depends if you are just using AI for translating, or if you are using AI, for example, to take decisions of people. If I give you a loan or not, if I contract you or not, you have to explain why this AI tool has taken this decision.
Okay, so that's actually quite interesting. Let me check if we have more questions. It look that we have been covering most of them, and we have like 3 minutes to go. I want to thank you again, Paula. It's quite interesting. We have learned a lot with you. Like we will have many, many, many more questions, but I think that it is a very good introduction to, and we've gone into quite a lot of deep matters. I would love to have more sessions, maybe in the future. Maybe we can prepare another one for a specific subject matters that you have actually already expressed, that there is a lot of things to be talk about. I thank you so much for your time. I thank you everyone for attending, and I hope that we can continue collaborating together in the future. And thank you for all the
It
participants.
will be a pleasure.
Okay, so have a lovely day, and I'll see you in the next one.
Okay,
Hopefully.
thank you very much, Maria. Have a nice day.
You too. Bye bye.
Bye.